Friends, hello and welcome to another live episode of The Legal Breakdown. I am Jason Sansone with Sansone Howell Attorneys at Law, and I think you're going to enjoy today's episode. As always, we want to remind our listeners that the show goes out live on our host station, KTLV 1220 AM radio. And if you are not in the range of the terrestrial radio broadcast for KTLV 1220, you can listen through the TuneIn radio app. The video stream goes out live, simulcast on Facebook Live through the Sansone Howell Facebook page. You can find all of these links on our website at sansonehowell.com. SANSONEHOWELL.com. Or if you're not able to watch live, former episodes are posted to YouTube for the video or on the audio format on Google Play, Spotify, and the Apple iTunes directory. Well, friends, just a few days ago, we had Memorial Day weekend. We had the great holiday, and unfortunately, with that comes one of the three highest days of the year for DUI wreck and DUI fatality. That, unfortunately, which one is the highest tends to rotate throughout the year, but 4th of July, Labor Day, and Memorial Day are consistently the very worst times of the year for DUI, both arrests, accidents, and fatalities. And so while I very much hope that no one listening has committed any of those offenses or knows anyone committing those offenses, we do want to still take the time on this show today, talk about DUI law, break down what that means in Oklahoma, and inform the listeners. And then, of course, hopefully a little of that will scare some of us straight or anyone who maybe was even ever fringing on those things. I cannot stress enough that there's always good alternatives, especially in this era of ride sharing with Lyft or Uber, that after I get done with this segment, you definitely are going to know that you do not want to get arrested for DUI. So let's start out. Let's talk about what is, in Oklahoma, a DUI. Well, the law states it is unlawful and punishable as provided in this section for any person to drive, operate, or be in actual physical control, we're going to come back to that, of a motor vehicle within this state, whether on public roads, highways, street, turnpikes, or public places, or any private road, street, alley, or lane which provides access to one or more single or multi-family dwellings. So we're going to get to what some of the qualifying factors are, but I want to start out by breaking down a lot of common misconceptions. Oh, I'm in a parking lot, that wouldn't count. I'm in a private place, private road, that wouldn't count. No. If you heard what I just read off, it's very clear. If you're in a car, pretty much doesn't matter where or how. If it's connecting in any way, houses or residences, this is going to qualify. And it's not just operating the vehicle, it's what we call APC, or actual physical control. So if the law enforcement can show that you had the ability to use the vehicle, whether you were or were not, it's the exact same offense as a DUI. So if you're passed out in the driver's seat with the keys in the ignition, that's APC. You're passed out in the driver's seat with the keys in your pocket, that's APC. You're passed out in the driver's seat with the keys in the passenger seat, that's APC. You could take the keys, you could start the car, you could have been using the car. Those are all, in the eyes of the law, the same offense. So you need to be mindful of that. I know that sometimes people want to do the right thing. They want to sleep in their vehicle. If you're going to do that, make sure you lock the keys in the trunk or some other way that you can clearly state, prove, argue that you did not have the ability to be in actual physical control. You were trying to sleep it off and do the right thing. You don't want to get a DUI inadvertently. But so then what are some of the things that qualify of APC or DUI? Showing that you're under the influence of alcohol, testing on a blood or breath test over 0.08 blood alcohol content, being under the influence of any Schedule I chemical or controlled substance. So in other words, if you are found to be impaired by narcotics, testing under the influence of any other substance other than alcohol, which would also render a person incapable of safely operating or driving a motor vehicle, or any combination of drugs and alcohol. So it's intentionally designed to be pretty broad. You could still technically be charged with a DUI even if you tested on a blood or breath test below 0.08. So that's another thing that comes up sometimes is, well, I was only 0.07. True, but if you weigh 90 pounds and you hadn't eaten in 2 days, you could have still easily been impaired. And if the officer can show that there was impairment, you might lose that fight. So be aware of all these different elements, but obviously the most common, the easiest, is that you took and failed a blood or breath test. And on that note, we'll take just a second to talk about blood tests. In Oklahoma, you do have the right to a blood test, but it is not a primary test. It's a secondary. Basically, you can take it to validate the breath test, but you can't refuse to do the breath test and say you want a blood test. You've got to take the breath test, and then they have to give you the blood test. However, keep in mind, you also have to pay for that blood test, so don't be shocked later if you get a $1,000 bill from the hospital after all of that process. But, it's come up before where people state, I told the officer I wanted to do a blood test, but I refused to do the breath test. If they didn't give you that blood test after you refused the breath test, that's legitimate because it's a secondary, it's a validating test. You don't have to just get that. So we've defined what DUI is. Here's now where we've got to really explain why this particular thing, for individuals more so than attorneys, can get complicated and confusing because you're fighting two battles simultaneously. On almost any other offense, crime, you're just dealing with the criminal element. You're just having to go to either a municipal, a county, a federal court, and of course at risk is your civil liberties, your rights and your freedoms. It could be anything from you're on probation to you're incarcerated to life to the most heinous offenses with capital punishment. The state may take your life. That's the criminal side of things. DUI also has what we think of as a civil side of things, and that's the fact that you have a privilege, not a right, to operate a motor vehicle, and you have a license from the state which permits you to operate a motor vehicle. And so they're not the same system, they're not the same process, they're really disconnected. They've got some interplay, but you're going to be fighting those on two different fronts, and the freedoms, protections, liberties involved are different on different fronts. So we're going to be talking about the criminal side. That's where you're going to be going to court. And we're going to be talking about the driver's license side. That's through the Department of Public Safety. Okay, so I want to start out talking about the criminal side. In Oklahoma, we've got courts at all different levels. Many cities have municipal courts where they have the right to enforce ordinances. Then, of course, the state of Oklahoma has courts which are broken down into judicial districts, and each one's going to be seated in a county. And then, of course, beyond that, we've got federal and other things. It's common for misdemeanor offenses to be a violation of both a city ordinance as well as a violation of a state law. For example, assault and battery. If you live inside Oklahoma city limits and you get into a fight, you broke the city ordinance and you broke the state law. So it depends on which law enforcement agency is the arresting agency, how they choose to charge you, and then where those offenses go. So if you get stopped by the Oklahoma Highway Patrol because they're a state law enforcement agency, guaranteed you're going to be in county. You're going to be in Oklahoma County Court if you live inside of Oklahoma County limits. But if it's Oklahoma City Police Department, odds are you're going to end up in Oklahoma City Municipal Court for that particular offense. Here's why I'm breaking all this down, though. With DUI, historically, it was exactly the same. So it made it unfortunately common that people would get many offenses scattered across the state in small cities, or maybe they got into multiple offenses in the same city, but those didn't report back. And the reason being is our municipal courts don't have all the same record-keeping process as our major state courts, as the county district courts do. So we call municipal courts, whether they're what's called a court of record or court not of record. And without going into all of exactly what that means, The short answer is the Oklahoma law bases the requirement to be a court of record or not on population, and only 2 cities in the state currently are above the population requirement to be a court of record. You can guess that's Oklahoma City and Tulsa. The others are not. So Del City, Midwest City, Valley Brook, Moore, Norman. Those are technically not courts of record for the municipalities. Well, in 2016, the state legislature passed a law that changed it, where if you were not a court of record, you couldn't do DUI. So DUI has to either be in a county court, a district court, or one of the 2 major municipal courts that are courts of record, Oklahoma City or Tulsa. So that's where we start off with our conversation, being that depending on who stops you, if you live in Tulsa or Oklahoma City, could affect whether you end up in a city or county. Like I already mentioned, Oklahoma Highway Patrol, guaranteed going to end up in county. The city of Oklahoma City, the city of Tulsa, pretty good odds you're going to end up in their municipal courts. But if it's Midwest City or Del City, you're still going to end up in county because they cannot charge it any longer as a municipal offense under city ordinances. Okay, well then, what if this isn't your first? If this isn't your first, you run the risk of this not being a misdemeanor. If it's your first possible offense for DUI, it's going to be charged as a misdemeanor. However, in vain of everything we just talked about of why we have these records, why we want to make sure that people cannot just get 10 DUIs scattered across small municipalities across the state. If this is a second offense within 10 years, it is enhanceable to felony. It's the 2 in 10 rule. And so you need to be aware of that. And in addition, you need to be aware that the fact that you may have expunged a prior DUI is not going to save you from that enhancement. Very specifically, the Oklahoma law actually reads that records expunged pursuant to a bunch of paragraphs shall be sealed to the public, but not to law enforcement agencies for law enforcement purposes. Records expunged of this section shall be admissible in any subsequent criminal prosecution to prove the existence of a prior conviction or prior deferred judgment without the necessity of a court order requesting the unsealing of the records. And so that is the expungement statute for Oklahoma, which is 22 OS 18. So if you had a first offense DUI, you get it expunged, and 8 years later, you inadvertently, not inadvertent's probably not the right way to say it, but you make a mistake and you get stopped again. That could be a felony. They could enhance that because it's the second one within 10 years. So you need to be aware of that. But so the criminal side of things, I don't want to make light of, but I do want to spend more of our episode today on the driver's license side, because that really is where, frankly, it's going to have more penalization. It's going to hit your pocketbook, and it's going to affect your lifestyle more than likely a first offense DUI will in the state of Oklahoma. And that's intentional. That's not accidental, because the legislature has been working for years to get this message across to decrease drinking and driving. That in reports in 2016 showed that from 2000 to 2010, we had one of the worst rates of DUI reduction in the United States. And so the legislature over the last decade has been rather aggressively working to enhance where they can some of these penalties to make sure the message is driven home. And so, again, I don't want to make light of either side of this. The criminal side's irrelevant, but unfortunately, it's probably not the side that's going to have a lasting impact for most people compared to the driver's license side. So on the criminal side, it's frankly, like most things, going to come down to a plea agreement. It's going to be a deal that's going to be between the prosecutor and your attorney. And what that entails, as far as whether that's a deferred sentence or a suspended sentence, or you're just taking a blind plea, all depends on your record. Is this your first offense at all, period, or this is just your first DUI, but you've already got a criminal record? It's going to depend on the county you're in and that particular DA or assistant DA. But a lot of times around here, what you're looking at is you're looking at 1 to 2 year deferred sentence for a first offense. A deferred means that at the end, it would be very quickly expungible. It's not going to show as a conviction. You're going to have to do certain DUI classes, alcohol awareness classes, and potentially either if you were not likely to be in addition to, but possibly if you didn't have to do the driver's license side, you may have interlock requirements. But most of the time, interlock requirements on the criminal side are irrelevant because you're going to have greater requirements, and those are already going to be part of probably the driver's license side issues. But say you manage to beat the driver's license side, as we'll go into, or you don't have any interlock requirements there, then you might still have interlock requirements as a result of that plea agreement or that supervised probation that you would have in the municipal courts. In Oklahoma City, I can't speak to Tulsa, but I can speak here. It would be a probation. You're going to have probationary fees throughout the process of that supervised probation and other things. So, what are you looking at? Well, you're looking at money, you're looking at fines, you're looking at court costs, you're looking at AA classes, you're looking at having to do other drug and alcohol assessments and classes. So it can get very expensive. And it is important that you do all those things and you complete that. But again, I think, for a lot of people, as they'll find, because of the extra requirements to get their license back and the time period that it can affect them, that's going to be possibly more frustrating or more causing changes in behavior, habit driving as they need to be. So let's talk about that now, because we are at the halfway mark for our episode. We're about 16 minutes in. We've got 14 to go. I want to dig into the driver's license side. So I already touched on driver's licenses are not a right. Contrary to what, obviously every 16-year-old thinks or what we all feel, it's a privilege. There's absolutely nothing in the Constitution says you get to drive. It's not a protected class. It's not discriminating based on gender, race, ethnicity, or religion. It's simply, I'd like to drive. Well, that means that you have to play by the rules if you'd like to drive. And of course, if you unfortunately are stopped for DUI, odds are they're showing you didn't play by the rules, so you don't get to drive anymore. So what all does that entail? Well, number one, if you are stopped, obviously they're going to ask you to take a breath test. If you take that and you fail, or if you refused to take that, the arresting agency is going to provide you with a notice of revocation of your driver's license. It's very, very important that you pay attention to everything on that particular piece of paper. Most importantly, that you have a very limited period of time in which to act if you don't just want to accept the results. If you wish to request an administrative hearing before the Department of Public Safety, you must do that within 15 days. Day 17, you go to a lawyer. We can still deal with the criminal side. It has much longer timelines, almost guaranteed you won't have gone to court yet. You could get continuances. You can do other things. But when it comes to the driver's license side, that is the time-sensitive part. If you get stopped, you get a DUI, you need to be calling a lawyer quickly or on your own taking action to request that administrative hearing. So what all happens, of course, again, if you failed the blood test, failed the breath test, didn't blow, some of those things. There's both revocation periods as well as mandatory interlock periods. And so out of the gates, depending on how many times you've had DUI revocations or driver's license issues with the department, we've got this revo period. That can be, under circumstances, what we call modifiable. Modifiable meaning that you might be able to get an interlock requirement added and substitute as opposed to just having your license straight revoked. If you don't want the interlock period, maybe you can't afford the ignition interlock because it costs about $75 a month plus all the extra fees to DPS, then you might try to just wait it out. You might let it be revoked. Okay. But then we've got the ignition interlock period. So what does that mean? That is going to be an additional, and we'll talk about what would trigger that, but those are enhancements, and they would start after the license reinstatement, after the revo period. So you had the revocation, you may or may not have got it modified, but then, depending on the circumstances, you might have an ignition interlock requirement, which for some, if you got the modification, seems like a no difference because of the fact that it's just going to continue. You're going to have the interlock for the revo period under the mod, then you're going to have the interlock afterwards. But it is an important distinction, number one, because you can wait out and not have to worry about that revo period. So if you have a first period, revo, 6 months, you don't want to get ignition interlock, fine. But then you don't ever bother to get the ignition interlock installed and proof that you had it. You can't just wait 3 years and come back to TPS and say, I would now like my license reinstated and I don't want to have the interlock requirement. You have to have the interlock requirement for the time period. You've got to show you have it for that period. There's no getting around it. There's no waiting it out compared to the revo period. So starting out, for a first revocation, it's a 6-month revocation period, and that's modifiable to have the ignition interlock for Class D licenses. For a second offense, it's a year, and for a third offense, it's 3 years. But notice I pointed out, you can only modify a Class D. So with anything other than that, you're in trouble. If you've got a CDL, you need to have already called top DUI lawyers and be ready to do anything you can to try to protect yourself, because really this whole episode and everything we're talking about is just the individual consumer, person, citizen, not commercial motor vehicle in any way, shape, or form. You're not going to mod a CDL. You're not going to have interlock on a CDL. You're just going to lose it. But so if first offense, you test under 0.08, or sorry, you test under 0.15 but over 0.08. Of course, you're going to be over 0.18 or we wouldn't be having this conversation. But if you're under 0.15 and you test, you're not looking at an enhanced interlock period. You're only looking at that 6-month revo. I shouldn't say only, but you're looking at the 6-month revo. Then the interlock periods we've been talking about come into play for what are defined as repeat offenders and excessive users of alcohol. At least that's in the words of the state. So if on the first offense you blow over 0.15 or you just refuse to blow, they're going to tack on an extra 1.5 years of mandatory interlock. So that is going to turn that first time that was 6 months, that was 180 days, into 2 years. On a second, you're adding 4 years. So where I told you it was 1 year, now you're really looking at 5. And on the third offense, you're adding 5 to the 3, so you're looking at 8. And again, these are important distinctions because the first part you can wait out. You could just have it revoked, but you don't ever have to bother with the interlock if you don't want it and you can't afford it. The second part, you have to have the proof to the state, or you're going to have some trouble eventually ever getting that reinstatement. Well, then you're saying, what about my job? What about work? Are there other circumstances to this modified license? I've got to drive a vehicle for my work, but it's not a CDL. Yeah, that's true. There are grounds for those things that, in fact, you could get a letter from your employer that states they do not want to install the interlock on any of their vehicles. It's got to be in writing. It's got to be notarized, and you can provide it to the department. And if you do that, the Department of Public Safety, and it's not a vehicle that requires a CDL, you might be able to continue to drive that particular vehicle for work without having to have the interlock requirements. However, a couple problems with that plan. Number one, that's only going to qualify if the company is truly a separate business. So if you're self-employed, if you own all or part of that corporation, or you exercise any control over the business, which we're trying to get the interlock off of, yeah, that's not going to work. You can't set up your own LLC, have a company vehicle, and then say, I'd like to not have to have the interlock on it. It can't be someone that you are related to within the first degree or resides in the same household of you who owns the business or exercises control over it. So you can't have your brother give you a job and then they give you a company truck and then you'd like to drive that without interlock. And the problem, of course, for most employers where this really comes into play is that there's no way they want to take the liability from a matter of insurance standpoint to allow you to continue to operate a vehicle after if it possibly been convicted of a DUI or lost a revocation hearing on that. That's not something that almost any employer is going to stick their neck out for an employee on. So don't count on this. It's technically possible, but I'll be honest, I have never actually seen it to date. We've had people always want to entertain the idea, talk to their employers about it, but I have yet to actually go all the way through with getting a client on a DUI able to drive a motor vehicle owned by an employer without having the ignition interlock. Unfortunately, usually if you drive in any way for a job, you're looking at termination, not some kind of assistance or support. So going back, we defined DUI. We said that could be actually operating the vehicle or it could be actually physical control. Doesn't have to necessarily be in motion. It can be on any road. Doesn't mean whether it's public or private it's going to save you. You could be in a parking lot. You could be in a drive-through for Taco Bell. Same results. Doesn't matter that you do or don't test over .08. Sure, that gives better evidence to the state. It makes it an easier slam dunk, but it's not the end-all by any means. Impairment is really what you're trying to demonstrate across the board. We've been talking alcohol heavily, but obviously drugs are going to put you in the same category. So, oh yes, our state has legalized marijuana for medicinal purposes, but if you use that and you decide to operate a motor vehicle, that's not going to come close to saving you, just like alcohol has always been lawful for consumption by adults, but it doesn't mean that you can operate a motor vehicle when you are under the influence. So these are real concerns and, of course, things that need to be sorted out. But so we talked then, from this point, we're taking a two-part process. You've got the criminal side and you've got the driver's license side. The criminal side is going to follow either the standard misdemeanor or felony process, depending on whether this is your first or your second possible offense. If this is your second, if it's 2 and 10, you're looking at the felony process. But with a misdemeanor, you're going to end up entering a plea, probably not guilty. You're going to have multiple settings and hearings and continuances. You could go all the way through to either a bench or a jury trial, but very, very unlikely. Most likely, your attorney is going to reach a plea agreement with the prosecutor, with that assistant district attorney or assistant city attorney, at which point then you're going to meet the requirements or go do what the requirements for that particular plea agreement are. Some time period of deferred sentence, fines, court costs, payments, supervised probation, drug and alcohol assessments, AA classes, those things. But on the license side, okay, we mentioned you're going to get this notice of revocation from law enforcement, from an arresting agency. Maybe you were in jail and bailed out. You should have all that paperwork by the time you are departing that facility. It's going to tell you very clearly, and you need to pay attention, that you have 15 days to do something. Because if you don't, everything we talk about is guaranteed going to happen. Doesn't matter whether you want to fight it, you disagree with the testing standards for the machine, maybe they didn't give you the proper time period, it's called a deprivation period, between the two required tests. All these different things could be issues that a good attorney is going to spot and is going to use to help you, but doesn't matter if you blow the time period. So you're going to want to get in within 15 days. Your attorney is going to request a administrative hearing with the Department of Public Safety. If you win that, hey, great. Then game over for the state. You automatically get your license back. You just have to deal with the criminal side. If you lose that, then you could appeal it into district court and you could continue that fight, or you could be asking for a mod contemporaneous with the district court appeal with the DCA. It's also possible to request a mod simultaneous to when you request that appeal before a hearing before the Department of Public Safety, and then you get that mod and you just end up doing that and you end up striking the potential hearing. So it all depends on what the client's objectives are, whether or not we really have grounds for possibly trying to have that administrative hearing, or we're just wanting to get them on in the first place. That's going to be a conversation between, of course, an individual and their counsel, and it's going to be very, very fact-specific. And frankly, it also depends on the quality of the law enforcement agency, and I don't mean that derogatory to any law enforcement. It's more complementary to certain ones, that the reality is the percentage of time that you're going to succeed in beating any of these, whether it's a criminal charge or whether it's a license revocation, comes down to the amount of experience and training of that law enforcement agency. You can put all the way at the top of the list Oklahoma Highway Patrol. They have their own academy. They're very experienced, and you are going to be in trouble if they've got you in their crosshairs. So obviously, Oklahoma City and Tulsa are number 2. Friends, we are out of time. I'm getting the shut up buzzer. So we have gone all the way. I hope you've learned a lot. We're going to continue this conversation in a future date. Be safe out there. Hopefully no one needed this advice today.